Have you been denied to inherit your father's land because you have worked very hard and bought your own property? Can somebody who has a PhD, somebody who has a bachelor's degree, somebody who has a good job come to fight for land against a brother who dropped out in class 2? The judge is saying, if a son works and buys land, whether that land is next to his father's land, that is private property. He cannot be told you cannot inherit because you have already bought your land. Any property bought by a son or a daughter cannot be lumped together with the property of their parents that is there for that is available for inheritance. Whether you have 1,000,000 acres of land, that property is yours. Work hard. Don't be saying, I'm the least privileged in this family. When my father dies, I'll be given this property. What your brothers have out of their sweat is theirs. Welcome to Court Helicopter Explainer. We are dealing with this question. Have you been denied to inherit your father's land because you have worked very hard and bought your own property? Are you very industrious as a daughter, as a son? You own your own apartments. You own your own land. You own your own properties. You own your own cars before your father dies. When your father dies, then your father writes in the will that because you own property elsewhere, because you are successful, you cannot inherit this land. You cannot inherit any of the estate. Have your family's members said that you are very successful? Wakili Omari is a very successful lawyer. Bramwell Wazala is a very successful journalist. He has money, he has property. We don't need to allocate him this property. What? How can he come to fight with us? Put this scenario. Your family has only 2 acres of land. You are 12. 3 daughters, 9 sons. The daughters have bought their land where they have been married. 3 sons have developed themselves. They have land in Nairobi, they have land in Kajiado, they have land in Kisumu, they have properties elsewhere. The last born says, you guys live. Your father, our father, educated you, and you have good jobs, you have good cars, you have properties elsewhere. Don't come to scramble over this land because munapigana ya nini? This is the question that very many families are facing. Is it a way to condemn industry? Is it a way to discriminate the hard-working siblings in the home? That is the question. Can somebody who has a PhD, somebody who has a bachelor's degree, somebody who has a good job come to fight for land against a brother who dropped out in class 2? Will they get land? Will they inherit equally? One refused to go to school. He's a village. He's a village truant. There's nothing he does. And then he says, nyinyi watu wa Nairobi, enda, hii shamba ni yangu. You cannot inherit this land. This is a question that appeared before the learned judge, Justice Namisi J. on January 16, 2026 in the family appeal number E02628 of 2023. This is the matter of Patrick Oliver Kaingwa versus Stephen Njoramba Kaingwa. It was an appeal from a ruling of Honorable Wanjala, a senior resident magistrate, that was delivered on 22nd March 2022 in FICA Succession Course number 399 of 2015. What are the issues in this matter? The gravamen of this dispute lies in the distribution of a land. The magistrate's court, in a ruling, distributed the property in a manner that effectively excluded the deceased's branch of the family from inheriting the portion of the land attributed to the matriarch, seemingly on the premise that the deceased had already acquired a separate portion of land during his lifetime. What did the judge say? In paragraph 28, the judge talks about a fundamental principle of succession law recognized across common law jurisdiction, and specifically in Kenya, is that self-acquired property is distinct from ancestral or family land. Self-acquired property is distinct from ancestral or family property. A child's own industry cannot be penalized. If a son works hard, buys land, and registers it, that land is his private property. It is not a gift from the parent, even if it is adjacent to the parent's land or consolidated with it for convenience. The judge is saying, if a son works and buys land, whether that land is next to his father's land, that is private property. He cannot be told you cannot inherit because you have already bought your land. Paragraph 29. The tribunal specifically found that the deceased bought 2.5 acres. A purchase is a transaction for value. It is antithesis of a gift. Therefore, the 2.5 acres cannot be brought into the hodgepodge under Section 42. It is not an advancement from the matriarch's estate. It is the deceased's separate property. The judge is saying that is a property away from the matrimonial, that is the inherited property. To all otherwise, as the trial court essentially did, is to rule that a child who buys property forfeits their right to inherit from their parents. This is logically unsound and legally unsupportable. It amounts to the expropriation of the appellant's father's private property to subsidize the respondent's inheritance. The judge did not agree with that. In paragraph 33, the judge says there is no provision in the Act that allows a court to deviate from equality based on the relative wealth of the siblings. The fact that the deceased had his own 2.5 acres is irrelevant to his entitlement to the share in his mother's 4.1 acres. Paragraph 39. The right to property and equality are enshrined in Article 40 of and 27 of the Constitution. Article 40 protects the right to acquire and own property. The deceased had acquired 2.5 acres lawfully. To effectively confiscate this property by counting it as his inheritance violates the constitutional protection of his private property. What did the judge do? In paragraph 42, the appeal is meritorious. The trial court erred in law by failing to distinguish between self-acquired property of the deceased and the ancestral property held in trust, thereby occasioning a miscarriage of justice to the appellant and the beneficiaries of the deceased estate. This is a judgment of Justice Helen R. Namisi, delivered on the 16th day of January 2026. What is the import of this decision? The import, one, is that any property bought by a son or a daughter cannot be lumped together with the property of their parents that is there for that is available for inheritance. Whether you have 1,000,000 acres of land, that property is yours. Article 40 of the Constitution provides protection of individual property. Then you have a right to inherit your father's property, which is 2 acres, and you must share the 2 acres together with your 12 siblings. So, if the 12 siblings will be given 0.5% acres, then everybody will be given 0.5 acres. But your 1,000,000 acres shall be independent. This is the principle the judge is saying, that don't punish industry. What does Court Helicopter Dan Sanomari tell you? Work hard. Work hard. Don't be saying, I'm the least privileged in this family. When my father dies, I'll be given this property. The last ones have been saying, me, I'll wait. When my parents die, I'll be given the house. I'll be given the cows. I'm the least educated. Today you got it. What your brothers have out of their sweat is theirs. Wakili Dan Sanomari, always a pleasure together with you.